Good morning, everyone. My name is Michelle and I'll be your webinar moderator today. The webinar today is sponsored by NatRoad's Platinum partner, BP. NatRoad members can save thousands per year with the highest fuel discount in the industry. Plus, Qantas Business Reward members earn Qantas points every time you use your BP Plus fuel card. Start saving and earning today with BP Plus. Today's webinar is being presented by David Leadbetter and Jessica Downey from Wage Inspectorate Victoria. David has worked in investigations and compliance for over 20 years across various agencies, both in state and federal level. He has also worked as a private investigator. David joined the Wage Inspectorate in 2019, tasked with development and implementation of the regulatory framework for ODFC. He currently leads a team of 3 authorised officers responsible for regulation of the ODFC Act. Jessica has worked in investigations for 13 years, most recently for the Victorian Ombudsman. She has led investigations into the Business Support Fund, Kinship care and disability abuse reporting. Jessica is a lawyer and leads the wage theft investigation team, which includes 2 team leaders and 7 inspectors. Like always, we'd love to hear from you during today's presentation. If you have a question, please feel free to type it in the Q&A section at the bottom of the screen. You may send in your questions at any time during the presentation. So welcome, David and Jessica. Over to you.
Thank you, Michelle. So thank you everyone for attending and hello. My name is David, as Michelle just mentioned. So I'll kick off the session. So as Michelle mentioned, I'm the current team leader within the ODFC team. And Jessica, who will present shortly, is the Assistant Director in the Wage Theft team. So just to cover off what we're going to cover off today, I'll just give you an overview of the Wage Inspectorate Victoria, the Owner Drivers and Forestry Contractors Act, the changes to that act and what they mean for you and for hirers, the regulations and the code of practice. I'll just touch on that and I'll show you where you can find more information around those. I'll cover off our audits and how we actually conduct our audits, our enforcement hierarchy, or the way that we are currently working with non-compliance. And then I'll pass that over to Jessica to talk about wage theft. And then I'll cover off where you can find some of this information around ODFC and wage theft, all the links you need, contact numbers and so forth. And then we'll answer any questions that you do have. So just to give you an overview of the Wage Inspectorate Victoria, it's there to enforce rights and obligations under a range of Victorian industrial relations laws. And what we focus on is protecting vulnerable workers. We'll investigate deliberate exploitation and willful disregard for the law. We'll focus on compliance, not just focus, but we'll do a lot of work in compliance in high-risk industries. And we'll also help to create a level playing field for businesses. Now, the Wage Inspectorate Victoria on the 1st of July this year became the Wage Inspectorate Victoria, which was transitioned to a statutory authority. And that has a new commissioner who's appointed and has responsibility for all the functions of the authority. Now, the inspectorate will no longer fall under the Department of Premier and Cabinet. So you may or may not be aware that we worked under Department of Premier and Cabinet. So as a statutory body, we're basically an independent body away from them, but we still work closely with our colleagues in the department, especially with the Industrial Relations Victoria. But we still continue our core functions. So we deliver regulatory oversight of the Long Service Leave Act, the Child Employment Act, the Owner Drivers and Forestry Contractors Act, and the Wage Theft Act. Now, in relation to the Owner Drivers and Forestry Contractors Act, I'll just refer to that as the ODFC Act. Now, that came into force in May of 2020. The Act had been in existence since 2005. So the Act actually was there. There were obligations for hirers and freight brokers under the Act, but there were no penalties attached to any non-compliance, and there was no regulatory oversight up until the 1st of May last year. And that was part of why we were asked to develop the ODFC team to do that work. So under the amended Act, people and businesses may now face penalties if they fail to meet their obligations. And as I said, our responsibility is to investigate and prosecute offences under that Act. So we have a dedicated team within the Inspectorate. There's myself, there's 3 authorised officers at the moment, and we have an Assistant Director who has further oversight above myself. So that team's there to help educate hires and freight brokers and contractors about the Act and ensure industry compliance. And I'll talk a bit more about a focus in that area shortly. So what do these actual changes mean? So the Act simply requires hires and freight brokers to provide certain information to contractors. And that change in the Act means that failure to meet those requirements now attract penalties. And the purpose behind that is to give the contractor, more information so they can make a better informed decision when entering into a contract. So they feel like it's more viable for them as a small business. So that's really the driver behind the changes, and to keep hires and freight brokers accountable. So what a hire and freight broker needs to do under the Act now is they need to provide the contractor the applicable rates and cost schedule and a copy of the Victorian Owner Drivers Information Booklet. Those two things need to be provided to the contractor at least 3 working days prior to their engagement. Their engagement is basically when they enter into the contract with the hirer. That's to give them time to review that information if they wish to, and as I said, make that informed decision when entering into the contract. They also have to provide the contractor a regulated written contract, and that doesn't apply to freight brokers, that's just for the hirer. And also, the contract itself needs to include a notice of termination of payment in lieu of notice, which only applies to the hirer as well. So if you want more information about the specifics of the Act, there's a link there that you can access, and you can view a bit more about what the Act requires. But they're the basic things that we look at from our perspective at the moment, that those main things are being adhered to by the hirer and the contractor. With regards to the regulations and code of practice, I won't talk too much about that, but the Owner Drivers and Forestry Contractors Amended Regulations 2021 basically were just changes to the regulations that came into operation in March this year. And the main change there was around some record keeping, but I'll touch on that in a second. And there's also an Owner Drivers Forestry Contractors Code of Practice, which also came into effect in March 2021. These were already in place, but there's just been some slight tweaks made to these to just better reflect the current climate in the sector. So I won't labour on too much, but you can access those links and find these things online. And a lot of this stuff can all be found on our landing page on the website, which I'll get to at the end. So I just wanted to touch on the record keeping in relation to the regulations. So it's really important for hirers and freight brokers to keep, well, it's probably best practice to keep records, and I think most people are doing that anyway. But now the regulations require that these records are kept, and I'll go to each stop point. So a copy of the contract where there is a written contract required. So to keep that on file. Evidence that both the information booklet and rate schedule has been given, and I'll get to that in a second. The date on which the contractor was engaged, the length of engagement, if there was any termination, the date of that termination, and any amount that was paid in lieu of any notice of termination. So they're probably records that are kept most likely anyway by most hirers and freight brokers. With regards to the information booklet and the rates and cost schedule being provided, there's a couple of ways that that can be kept. So you might have a handwritten log of when you provide this, and it could be signed off like a receipt book or something similar that the contractor can sign off to say they've received it. It could be part of the paperwork that's provided to them as a checklist, and they sign off to say they've received it and when. But we're also happy to accept, when we request information from you to say, have you provided this? You might forward us the email that you sent the contractor showing that you provided them the link to where the booklet and the rate schedule sits. So you don't have to physically provide them a physical copy of the booklet or in person. You can email them a link to the website which contains that information, which I'll provide later on as well. So, but it's important to keep those records, because if we come to you and say, look, we need to see that you provided this, we want to see a copy of the contract and information around when they were engaged or when they were terminated, we'd expect that would be available to us. So it's just best practice to do that. So that's why I wanted to cover off those key points. Now, in relation to the audits that we actually do, we started doing our audits in 1st of March this year. So the reason we didn't do them any earlier was for the most obvious reason was of COVID, and we were unable to really do some of our work in that space. But there was also a deferment of the Act by the Minister, so we weren't able to actually do anything up until at least December last year. So what we were able to do in that time is engage with industry as much as possible in different industry bodies. And we also did some trialing of our audit system to make sure that the system was in place, was working, and we could fix anything that needed fixing. So that time gave us that opportunity to do that. And then once we got to March 1st, we became fully operational, which meant that we were then conducting audits out in the field. And when I say in the field, we haven't been able to actually physically go out. At the moment, we've been doing a lot of our work remotely via desktop. So we have a very moderated and educative approach to enforcing the Act at the moment. And the reason being is, though the Act's been in place for a long time, there was no regulatory oversight, like I mentioned before. And I think out of fairness, we need to provide people the opportunity to get things right and get the right measures in place so they can be compliant. And I think the first option for us is to talk to the hirers and freight brokers, see where their level of compliance sits, understand how their business works a little bit, and there's any gaps that we identify, then we can work with them to get them up to where they need to be with their compliance obligations. And then it's down the track whether we come back to those hirers or freight brokers, say in 12 months' time, for example, where if the same things are occurring, then we can escalate our enforcement approach to the most appropriate outcome. But initially, we want to work with hirers and freight brokers to educate them around what the requirements are, because a lot of them aren't aware, and just to make sure that they know what they need to do. And then once they've got that in place, we'd expect that from that point on that there'd be a full level of compliance going forward. So as I said today, and as we continue, we'll focus on providing that information and support and guidance to help hirers meet their obligations. And in most cases at the moment where there's non-compliance detected, as I said, we're really giving more an educative approach to that. So we're just spending some time to say, this is what you need to do, this is what we've identified, so they're aware. And what we're doing is issuing a caution or an official warning notice. We're basically saying, look, we've identified there's a breach of the Act here. This is what it is. On this instance, we're not going to continue any further action, but you're being put on notice to say, well, you know, in the future, you need to make sure that you comply. And then when, as I said, we can take that action down the track if there's further non-compliance. But it's giving you an opportunity to get things right in the first instance. And we'll give you all the tools and guidance we can to help you get there. So just looking at that picture there, what we're looking at is the first tier or level at the bottom is education and guidance. You know, we sort of combine that with a caution or warning letter in most cases, and no further action is taken. The next level for us is issuing a penalty infringement notice. So a penalty infringement notice is a fine, basically, which I think most people are familiar with. So it is a form of litigation in the sense that it just takes away the burden of going to court. So, you know, if we find that, you know, we've spoken to a hirer before and there's been some non-compliance, we've issued them a caution or provided education. In 12 months, we go back, there's further non-compliance. Most likely we'll take the step of issuing a PIN. Where there's willful disregard for the law or it's more serious, we may issue a PIN in the first instance. We don't have to take that stepped approach if we don't want to. If we think a PIN's appropriate in the first instance, we'll do that. But to date, we really haven't gone down that road yet. We've really just concentrated on giving education and issued some warning notices along the way. And then finally, we can also refer the matter for prosecution. So we still have that option depending on what the circumstances are. So just to give you an idea of what our findings have been. So as I said, we became fully operational on the 1st of March this year. To date, we've contacted over 100 hirers. And we plan to do some site visits once that opportunity allows us. So, you know, with a bit of planning, we'll be able to get out there and hopefully talk face-to-face with some businesses and do some of our work out there, which will be, I think, beneficial for us and beneficial for them to see us out there. And we can talk and get an understanding of how the businesses work a bit more. Now, some of the main breaches we've identified today is pretty much across the board. So the main things, as I said, we focus on the information booklet, the cost and rate schedule, and having a non-compliant contract or also providing a contract. We're finding in most cases, because there's not a lot of awareness or hasn't been in the past, the breaches that we're finding are across those three quite evenly. There's not really a standout area that people aren't complying with. The information booklet and rate schedule, sometimes they are provided, but they're not provided at least 3 days prior to their engagement. So someone will come in, could come in off the street. They've got a truck. They want to start working straight away. They'll sign them up on the spot. Here's a contract, sign away. They might still give them the booklet, but they haven't complied because the booklet was provided at the time of engagement and they haven't had an opportunity to read that, take that away. And that's what the Act requires them to do, or at least, have that provided 3 days prior. So sometimes they're not providing it at all. Sometimes it's provided, but not, as I said, in the time frame that it should be. And a compliant contract. So in most cases, it's very rare that we come across where no contracts are in place. It's pretty much standard practice to have a contract when you're hiring a contractor. But what we're finding is a little bit of ambiguity, or people aren't sure what needs to be in the contract. So there's a few elements that need to be in the contract under our Act, but the main three are: it has to have the relevant periods of termination, depending on the vehicle type. It needs to have the rate of pay that they're being paid, and it needs to cover off the minimum income level or minimum hours that they're working. But just to make it clear, and we had to get some advice around this, but basically if someone puts in their contract, this is the rate that they're being paid, that covers off the section that requires a minimum level of income to be paid, because it's one and the same. Basically, that's the advice that we have. But without getting into the technical side of it, the three main elements are those that we need to look at in the contract. So what we do is we get a contract, we look at it. If those all those elements are there, they've complied. If not, then we go back and say, this is what you need to do and include in your contract. But as I said, contracts are being provided. There's just a mixture of stuff within the contract that's not being included, or what is in there is just not in line with the Act. So they're the breaches we're identifying at the moment. So that's where education is being focused on, is letting them know what they have to do and what needs to be in the contract. We don't give advice on contracts, but we might get to that a bit later. And I'll pass it over now to Jessica, who will talk about wage theft.
Thank you, David. Thank you everyone for having me today. So my name's Jessica Downey. I'm the Assistant Director of the Wage Theft team. As Dave mentioned earlier, the Wage Theft Act commenced on the 1st of July this year, and the commencement of the Act established the Inspectorate and made wage theft a crime in Victoria. The Act created 3 wage theft offences, the first offence being the deliberate and dishonest withholding of employee entitlements, including wages, superannuation, annual leave, long service leave, or allowances for things like shift work. The second offence being the falsification of employment records with a view to obtaining a financial advantage. And the third offence being the failure to keep employment records with a view to obtaining a financial advantage. These are serious offences and there are serious penalties. The court can impose a fine of more than $1 million for companies and up to 10 years jail, or over $200,000 for individuals found guilty of wage theft offences. The legislation was introduced to protect workers and level the playing field for businesses who are doing the right thing. The legislation applies only to employment relationships and not to independent contractors. However, an employer who misrepresents an employment relationship as an independent contract to avoid paying an entitlement, that is an example of a potential dishonest intention, which would be covered by the Act. So sham contracting, for example, would be covered by the Act. The legislation does not create any new obligations on businesses. It criminalises withholding of nationally regulated employment entitlements. The law is not retrospective, so we cannot consider withholdings before the 1st of July this year. The Wage Inspectorate receives reports from the public through its online reporting tool. We will also accept anonymous reports, which can provide us with intelligence about industries and employments more broadly. So our inspectors have a range of powers at their disposal to enforce instances of non-compliance, and those powers include the power to issue statutory notices, to enter and attend premises. We can do that with or without a search warrant. we can also, once we've investigated a matter, we prepare a brief of evidence, and we will engage with the Public Prosecutions Department in Victoria and look to prosecute matters and offences. Thank you, David. That's the end of the wage theft section of the presentation, but I am very happy to answer any questions as well. So please drop them in the chat.
Thanks, Jessica. And I think I might just touch on a couple of very quick things too. And Jessica just jogged my memory. With powers, one of the powers we also have under the ODFC Act for our authorised officers is a notice to produce. So where we request information from a hirer, and it could also be a contractor as well if we need to verify information. If a hirer fails to provide that information, we have the power to request that through a notice, and failure to adhere to that notice is also an offence in itself. So that's one of the powers that we do have. So, you know, most of the time, nearly all the time, hirers have been very cooperative with us and provided the information we've requested in the first instance, but we do have that opportunity to use that tool if we need to. And one of the things I just wanted to touch on, and some of the inquiries that we've actually had is around disputes of rates of pay. So a lot of contractors will come to us saying, look, you know, I haven't been paid the right rate. And that's something that's not within our remit. So it's not in the scope of our legislation to enforce. So unfortunately, if we get a query around the rates of pay or dispute around payment, what we do is refer that to the Small Business Commission in most cases, and they have an arbitration process where they can help mediate and go through that process with those parties. You know, and there's other civil options that a contractor may have, but unfortunately it's not something the Wage Inspectorate in the ODFC team can actually undertake. So just wanted to make that clear, because I think, yeah, there might be a bit of confusion around whether we can do that or not. And I think, yeah, especially with contractors who aren't aware of what we actually do in the ODFC team. So just wanted to point those couple of things out. But I just also wanted to give you the information on where you can contact us and where you can find some of this information. So firstly, with the ODFC team, someone can submit a complaint, and they can either do that anonymously, so they can put a complaint in. We are unable to contact them, so we have to rely on the information that's provided, but whatever that information is, we'll assess that and determine whether we can take any action from that point. But they can also submit an online complaint, which has more specific information and request some personal details. And then that allows us to then, depending on the information or what the matter is, we can then start an investigation and investigate the matter from that point onwards. There's also an inbox that the ODFC team have, which is up there, odfc@wageinspectorate.vic.gov.au. So we monitor that. If there's any queries or questions, we're able to look at that and provide a response, pretty timely response within a day or two, hopefully. We'll get back to you. So you can contact us that way. And the website, which is on the Business Vic website. So if you go into Business Vic and just type in transport and forestry or owner drivers, it'll bring you to the transport and forestry page. That page has everything that a hirer, freight broker or contractor needs to know. It has the links to the rates and cost schedules, to the information booklet, to the Act, to the Code of Practice, and to the regs. There's just a lot of information on there that will assist you and probably answer a lot of questions that you may have. So I'd encourage you to go out and have a look at that, that page and that website. And like I said before, if you are providing contractors the information booklet and rate schedule, as long as you email them or send through the link to the Victoria Business website, and more specifically the transport and forestry section, that's sufficient for us, because that directs them to where that information is. And obviously you can also call us on the phone. So that is our customer service delivery team that are trained to take calls and answer any queries you might have around owner drivers and forestry contractors. So you can contact us that way as well. And the wage theft is similar. I don't know if you want to talk to that, Jess, but I'm happy to just provide those contact details, the same phone number, so the customer service delivery team can answer those queries as well. The vic.gov.au website, which has details of wage theft and wage theft laws. And you can also make a wage theft inquiry, or you can make a report or complaint or report, same thing, but you can make a report on any matters you want to report, and then the team will assess that and determine if that can be investigated and then take it from there. So there are all the contact details for both teams. And that's it for the presentation as far as what we need to talk to. Is that if there's any questions, we'll happily try and answer them for you.
Thank you, David. Thank you, Jessica. We do have some questions. The first one is, as an owner driver, what do I do if I don't have a written contract for work?
Yep. Okay. So if that's the first instance, I would encourage is if they haven't provided you one, depending on what you've discussed with the hirer, I would first probably go to them and ask them, why they haven't been provided a contract, and if there is one, can that be done, and they can enter into that contract. But then they can come to us and they can report it to us, and then we can go and make contact with the hirer. So what would normally happen is, depending on what relationship they have with the hirer and whether they've spoken to them or not, I'd encourage them to come to us and either put in an anonymous report or a full complaint. And then what we can do is assess that, and we'll make a determination on how we approach that with the hirer. So we'll either do a couple of things. We'll either have enough information where we can conduct an investigation into the alleged non-compliance. We may conduct just an audit to see if we don't have enough information and we just think, let's just see if they actually are providing contracts. What we can do is we would ask them to provide a copy of the contract that they use to engage that contractor. And then we'll know from there whether they've complied or not. So, it's hard to say go to the hirer and ask. I mean, I would encourage that to see what their answer is and why they haven't provided it. And that might help us understand the reasoning behind why they haven't done it. But they can always either make an inquiry with us first, they can call, they can send us an email and ask us. But for us to actually do anything with that, we ask them that they lodge a report first off. And then that gives us the ability to then go and investigate it. And then we'll take whatever action we have to with the hirer. We can't really force the hirer to prepare a contract and present that to the contractor. All we can do is take the action on the basis that they haven't complied with the Act. But knowing that they'll have to be taken into account for not complying. Hopefully that answers the question.
All right, thank you. We have two more. So you mentioned that you can't look at disputes, but as an owner-driver contract, can you look to see that the contract conforms?
What we do is when we assess contracts that we're actually looking at where we're doing an audit or an investigation, obviously at that point we're seeing if they comply. But if there's someone coming to us saying, like, can you look, here's a contract, are we compliant with the Act? Look, we don't give advice. We need to be very clear on the fact that we don't give legal advice or general advice as such. What we do say is this is what the Act requires you to have within the contract, and give that guidance. So the hirer or whoever it is knows what they have to include in it to comply. But we do have on our website model contracts. So they're basically templates that have been developed in line with the requirements of the Act. You don't have to use them, but if you want to use them, they're there as a guide. And a lot of hirers do use them because they know that they're going to be compliant with the Act. They just have to fill in the relevant details. But they're at least a good guide. And if you want to go out and engage someone independently to draft a contract, or you draft it yourself, as long as it complies with the requirements of the Act, then it's okay with us. We're not experts in contract law. We're just there to make sure that the elements of the contract are in line with our Act. So we can certainly guide you in the right direction, but go to the website and have a look. If you want to have a look at a model contract, you'll get a sense of what needs to be included. And if you're not sure, I mean, we still encourage you to come in and ask questions. If we can give you the answer and we can provide guidance, we will. But when it gets to sort of giving advice on things, that's where we sort of can't do that.
Great. I have one last question. What happens if I make a genuine mistake with wage payments and then correct them? Can I still be subject to legal punishment, if not for wage theft, maybe more generally?
I might take this one, David.
Yep, go for it.
So the Wage Theft Act doesn't seek to criminalise people who have tried to do the right thing and made an honest mistake. So the word dishonest implies that we need to prove an intention or recklessness in relation to payment of wages. So if you have in good faith underpaid someone, I would suggest that you reach out to the Fair Work Ombudsman and you notify them. So they have a team of people who deal with self-disclosures of underpayments, and they can work with you to rectify that. There are still civil penalties for underpaying your employees, but they're managed through the Fair Work Ombudsman process. So I would recommend that you get in contact with the Fair Work Ombudsman.
Wonderful, thank you. So we have no more questions. Thank you, David and Jessica, and thank you everyone for attending today's webinar. If you have any questions, please send an email to info@natrroad.com.au and we can pass it on to David and Jessica, or you can use the contact details that they provided in the webinar. Today's webinar was recorded and will be uploaded to the NatRoad website. Have a great day. Thank you.
Thank you, everyone.
Thank you, everyone.